before we get started, I just wanted to acknowledge the traditional owners of the land upon which we're all meeting today. In my case, that's the land of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders, past and present. We've seen in the media that casual workers have been some of the most severely affected by this current lockdown, and also last year, the major lockdowns we had. And as we know, the legal definition of and boundaries of casual employment has been a major issue of public debate and consideration by the courts and the federal legislature over the last year or so. So as Director of the Centre for Employment and Labour Relations Law, along with my co-director Tess Hardy, it's fantastic to be able to host a seminar tonight on casual employment, seeking certainty in an uncertain world, and to introduce Paul O'Grady QC as our guest speaker on this topic. Paul, of course, as many of you would know, has been at the Victorian Bar since 2002 and is an experienced advocate in the areas of employment, industrial relations law, discrimination law and equal opportunity, administrative law, and occupational health and safety law. Paul's appeared predominantly in the federal jurisdiction, in the Federal Court of Australia, but also the Federal Circuit Court and industrial tribunals. And along with his extensive practice at the bar, he does find some time to contribute to the textbook Macken's Law of Employment, published by Thomson Reuters. Paul's also an honorary senior fellow here at the Melbourne Law School, where he teaches in our Masters of Employment and Labour Relations Law. He's also editor of the Practice and Procedure section for the Australian Journal of Labour Law, and he's chairperson of the Salary and Conditions Board of the Catholic Education Commission of Victoria. So it's with great pleasure I hand over to Paul to speak to us tonight. Thank you very much, Paul.
Thank you, John. The first thing I need to acknowledge is that I need to update my CV, but I'll wear the burden of a broader practice than what I actually do conduct these days. So I'll leave that to others. What I'll do is I'll just pop up the slideshow so that we can get up and going. Hopefully that will now show you slides rather than me. The last thing you want to do is look at me for the next hour or so. Over the next 40 minutes or so, I'll walk through a few things in relation to casual employment. Time really doesn't permit us to cover everything, so there'll be a couple of things that I don't go into, but will make passing mention of just for the sake of completeness. I propose to have a look at casual employment up until now, if you like, its history, a very brief history, just looking and separating out the meaning under general law, if you like, for want of a better label. I don't use the label common law meaning because there's no real common law concept of casual employment as such. Also, the meaning that's been attributed to the label casual employment in enterprise agreements and the new statutory definition, which was recently inserted into the Fair Work Act. I'll then turn to casual loading, and we'll have a look at some of the aspects of casual loading with a view to having a look at this issue of offsetting, if you like. I'll talk a little bit about offset under the current position or under the position prior to the recent statutory amendments, and we'll then have a look at new section 545 capital A, which is inserted into the Fair Work Act recently as well. The theme of seeking certainty in an uncertain world will rise to the surface throughout the course of the next 35 minutes whilst I go through this material. I'm sure it's likely to give rise to a number of questions, and I'll welcome those questions at the end. As John said, he'll field the questions. So let's just start with the question of what is casual employment. We'll have a quick look at some history, then I'll have a look at the two relatively recent decisions of the full court of the Federal Court of Australia, and just make some observations about the recent High Court hearing in Rosato, and of course talk about the onset of the statutory definition that John mentioned. Historically, casual employment as a concept in Australian industrial law first arose under the Engineering Trades Award in about 1920 or so. At that time, Justice Higgins provided for a 10% uplift in pay for casual labour for urgent repairs to ships. This was in the time of, in the age of weekly hiring, and the additional uplift was paid for the flexibility of calling labour in and out from time to time. Throughout the Depression years, through the late 20s and early 30s, you'll see from the slide that the casual loading as such was removed, but there was an allowance of 5 shillings per week introduced in lieu of holiday pay and average absences through sickness and the like. If we then move another 6 years or 7 years or so, the 10% loading was reinstalled for the use of casual labour, but the use of casual labour was no longer limited to urgent repairs. It was available as a general way of engaging labour in the shipyards. And the primary component of the casual loading at that time was for the value of paid leave entitlements foregone as a result of the flexible arrangements that we now all come to understand that operate with casuals. Upon the consolidation of the Medals Award in 1941, we saw for the first time the introduction of an award definition of casual employee, and it's one that we're now familiar with, and that is an employee who is engaged and paid as such. Not that helpful. But what the then Conciliation and Arbitration Commission did in the making of the award was to calculate the hourly rate for casual labour at 1/40th of the weekly rate rather than 1/44th at the time. The 44-hour week was the normal working week, thereby essentially giving the employees an uplift of about 10% on the normal hourly rate. That casual loading was later increased to 15% in 1963, and again in 1974 there was a further increase in the casual loading to 20%. As was often the case throughout this period, the changes to the Medals Award were more often than not by way of consent, having negotiated a deal prior to the making of the award at the time. This summary is essentially available to everyone through the Medals Casual case, which I cited on the earlier slide. And by way of observation, after a review of the history, the full bench of the Australian Industrial Relations Commission at the time, observed that what one sees through history is the need to set the casual loading at a rate which protects against allowing the exception, being the use of casual labour and the paying of the higher rate, to subvert the norm, being normal weekly employment or engagement on a permanent basis under the award. And it was decided at that time it was appropriate to make the loading at 25%. And I'll return to the breakup of that 25% when we consider casual loading in more detail. Now, one thing that has come under consideration when looking at the meaning of casual employment in the recent cases is whether the general law definition of casual employment or casual employee applies, or whether one should look to what is the standard industrial definition, engaged and paid as such. And this was the question that the full court was faced with in the first of the two recent decisions in Workpack and Scheme. Under the general law, the courts had, through a case of Hamzy, again a full court decision in terms of looking at the statutory unfair dismissal regime and the exclusion of certain types of casual employees from those unfair dismissal entitlements. The full court said that the essence of casual employment was essentially the absence of a firm advance commitment as to the duration of the employee's employment or the days or hours the employee will work. The engaged and paid as such standard definition in enterprise in awards has often flowed through to enterprise agreements, and it's really that definition that the Fair Work Commission picked up in the case of Tellem Civil in 2013, and it applied that definition to a question about the construction of the NES notice and severance entitlements at the time. So faced with this choice, the full court in Scheme said, look, really we're talking here about statutory entitlements. We're not talking about entitlements under a particular award or enterprise agreement. And so the court said it was appropriate to apply the general law meaning in Hamzy and not the designation approach that was apparent from Tellem. A consequence of that, of course, is that one needs to be a little careful when dealing with decisions of the Fair Work Commission and its predecessors in decisions such as the 4-yearly review of modern awards. And I'll refer to that decision again a little further on. So what is this general law meaning of casual employment? Well, what the court said at paragraph 182 is that the general law meaning is an objectively demonstrated existence of the I'm sorry, I've just lost part of my screen, so I just need to turn to my notes for that definition. The objectively demonstrated existence of a firm advance commitment to continuing an indefinite work, obviously subject to rights of termination according to an agreed pattern of work, is something that will demonstrate a contrary intent. So contrary to the intent that the employment be casual. And you'll see when we get to it that the recent statutory amendments pick up that phrase, which has its origins in Hamsey, and you'll see there that the court in Skene went on to say that the sorts of indicators that one might expect from casual employment are the absence of a requisite firm advance commitment, of things such as irregularity, uncertainty, unpredictability, intermittency, and discontinuity in the pattern of work. Now, when the matter came up again for consideration in the second of the recent full court decisions in Workpac and Rosato, and one needs to be careful when considering Workpac and Rosato, one needs to think about how the matter came before the courts. Bear in mind that this is an application by the employer Workpac for declaratory orders in relation to the nature of the employment. This was not a case in which you had an employee seeking recovery of award or agreement entitlements or seeking recovery of NES entitlements. This was a case that was brought before the federal court, and by agreement between the parties and also a number of interveners, went directly to a full court to determine some of these underlying legal issues. At the outset, Workpac accepted that the general law test of firm advance commitment was the correct test. At issue, of course, in the case, though, was the application of that test, and in particular, whether the firm advance commitment is assessed at the time the contract is made or whether it is open to the court to take into account what takes place during the course of the engagement as a matter of practice. And interestingly, whilst the court ultimately decided that they didn't have to decide that issue because they were able to decide the case on the facts, Justice Bromberg favoured the latter view, that is, you take into account all the circumstances, whereas Justice White favoured the former view, that is, one needs to look at the contract at the outset and identify at that point in time whether there is this firm advance commitment. Justice Willihan agreed with Justice White in relation to the assessment as to the casualness of the relationship. That of itself, that conclusion of the majority is of itself seemingly at odds with the full court decision in Skene, where there seemed to be a preparedness to take into account all the circumstances of the case. In terms of the application of the test, I've picked out a couple of paragraphs there from the judgment of Justice Bromberg. Crucial for His Honour was the fact that it wasn't the case that Mr. Rosato could just not turn up. He was never asked by Glencore whether he intended to turn up the next day or when he was rostered. And equally, Mr. Rosato never actually asked Workpac or Glencore whether he'd be required to work on the next day. In the analysis of Justice White, conveniently at paragraph 444, His Honour set out a series of propositions having assessed and considered the authorities on the issue, dating back to Hamsey and Tellem and all of those authorities. And His Honour there sets out over a series of 7 bullet points what he considers the relevant considerations in assessing whether or not the employment is casual or otherwise. The postulated firm advance commitment might be lacking, of course, where there's intermittence, informality and the like. might be absent if the employer can elect whether to offer work on a particular day, might be absent if the employee works only on demand or over a short period of time. The description of the employment is relevant, along with what the parties themselves decide the relationship should be labelled. The firm advance commitment does not have to be expressed, but it can be discerned from the employment considered as a whole, particularly where the contract is informal. So we have, from the reasons of Justice White, another dissection, if you like, between circumstances where the employment is formal, where it might be documented by way of a formal contract of employment or letter of engagement or offer and acceptance, and one where the contract is less formal, not wholly in writing. The statutory context will also be relevant, and account, of course, might have to be taken of changes in the employment relationship which occur after the commencement. And you'll remember in the Rosato case, there were in fact 6 what they called notices of casual employment, NOCEs. There was a series of 6 contracts in that case. And I'll make comment about that when I have a look at the definition under the recent amendments. Turning now from the general law, in both WorkPac and in Rosato, each of the full courts was prepared to apply the general law definition to the meaning of casual employee in the statutory minimum entitlements. Turning now to award and agreement-based entitlements in relation to casual employees. I've included in this slide a series of different definitions, if you like, across instruments. I've just picked this up from a survey of the landscape table, which is attached to the back of the recent Fair Work Commission discussion paper, where the Fair Work Commission, of course, is required to undertake a review of the casual employment provisions in modern awards as a result of the introduction of the new NES entitlements under the recent amendments. And as part of that review, the Fair Work Commission has circulated a table, and you'll see there's 5 definitions, all of which are reasonably similar in terms, but slightly different, and then a series of other formulations. There's other examples. What was interesting is that nearly 90% of the modern awards adopt this designation approach, whereby a casual is said to be someone who is engaged and paid as such, or engaged and paid as a casual employee. And of the enterprise agreements which were analysed, and it's not clear from the paper how many enterprise agreements were analysed. I think it says there a certain number of employees were covered by those enterprise agreements, but doesn't give the number of enterprise agreements. Again, about 80% adopted this engaged and paid as such definition. One of the reasons why the full court in Rosato was not prepared to adopt that designation approach when looking at the meaning of casual employee for the NES entitlements was that there was a lack of consistency in approach by the Fair Work Commission over history. In scheme, the relevant enterprise agreement before the court used the phrase casual FTM, and it didn't actually define in the enterprise agreement what a casual FTM was. That, of course, stands in contrast to the engaged and paid as such definition which was the subject of consideration by Justice White earlier in a case of Divine Marine. Instead, it was more like another case, another decision of Justice White a year later in South Gin, which merely required the employer to tell the employee the nature of the engagement as to whether or not they're casual or full-time or part-time. And in those circumstances, the full court in Skene said, well, absent any contrary intention, we think it's appropriate to apply the normal meaning. So on one view, the full court in Skene did not really need to determine the correctness of the decision of Justice White in Divine Marine. And to that extent, it probably doesn't undermine the consideration of the full bench in the 4-yearly review case of the standard award definition of engaged and paid as such. So what does all that mean? Well, Divine Marine, there the relevant definition was that engaged and paid as such definition. And Justice White really had a look at that and said, well, what does that mean? What does it mean, engaged and paid as such? The focus, of course, in that phrase turns on the word engaged. And you'll see there from the slide that His Honour said, well, look, this could really mean one of two things. It could mean that it's the way in which the parties themselves identified their arrangement at the time of its commencement, or alternatively, some objective assessment as to whether or not the person was engaged as a casual. Now, there are a couple of considerations in the agreement that was before Justice White in Divine Marine that led him to the view that it was really what the parties themselves identified as the arrangement in the circumstances. The first of those was that the reference in the relevant enterprise agreement was whether someone was specifically engaged in casual employment. That is, the question was whether at the time of commencement of the employment, whether they were specifically engaged as a casual employee. If not, they were taken to be either full-time or part-time. And the other was the formalities that were required to be met, so that these things had to be set out in writing. And so the focus was on what the parties decided at the commencement of the employment rather than what happened down the track. So turning next to Rosato, the second of the two full court decisions, because it was WorkPac, again, it was the same enterprise agreement. And so the full court simply said, we don't need to decide the correctness of Divine Marine because there is no definition. It's the same enterprise agreement. We're dealing with the same clause. We apply the general meaning. There's no need to take a different approach. So all of that brings us to the recent amendments. And what is this mess that the Parliament feels that it's required to fix up? There's a number of things that the Fair Work Amendment supporting Australia's Jobs and Economic Recovery Act, the long titles of these acts these days makes it not easy to use acronyms. I think I'll probably fall into the nomenclature of just calling it the Amending Act or the 2021 Amending Act rather than any aspirational description of what the legislation might be intended to achieve. Deals with a number of things. As John mentioned in the introduction, it provides a definition of casual employee. It introduces a new national employment standard, which is an obligation to offer casual conversion, and that is restricted only to businesses that are not small businesses. So small businesses are excluded from the requirement to offer casual conversion, but it does confer a right to request casual conversion on employees of all businesses. That's one area I don't propose to trespass upon tonight. Section 545 is the section that deals with the way in which, in assessing compensation for any claim for NES entitlements, the court will need to bring into account any payment of casual loading made in the belief that the relationship was casual when in reality it was not. There's also an obligation on the Fair Work Commission to review casual terms in awards and enterprise agreements. And as I say at the bottom of the slide there, we'll focus on the definition of casual employment and the remedial provisions in 545A. So turning to the definition itself, what I'll do is I'll just roll through the next few slides and I'll come back to this slide. In essence, the next few slides set out the entirety of section 15A. The starting point is it picks up the language from HAMSI and WorkPack, the absence of firm advance commitment. I'll come back to that. Then we've got subsection 2, which seeks to provide assistance in working out what that firm advance commitment might look like. It's assessed at the time the offer is made, and in making that assessment, regard is to be had only to these considerations. And again, I'll come back to this slide. Then we have, just to try and anchor the point even further, the Parliament saying, well, to avoid doubt, a regular pattern of hours does not of itself indicate a firm advance commitment. And a further avoidance of doubt provision, the question of the person, whether a person is a casual employee, is assessed on the basis of the offer of employment and the acceptance of that offer, not on the basis of any subsequent conduct. And subsection 5, the person remains a casual employee until their employment is converted under one of the casual conversion provisions, or the employee accepts an alternative offer of employment. The first thing I observe going back to 15A1 is the language offer of employment. It's an offer of employment made by the employer to the person, who ultimately, by paragraph C, has to be an employee as a result of that acceptance. That is to be contrasted, and I'm jumping between slides really just to show the distinction in the language that's used. The offer of employment is as distinct from an offer of work, which you'll see is one of the key considerations, in fact, one of the only considerations which are to be taken into account in making an assessment as to whether or not the offer and the acceptance of the offer of employment constitutes the creation of a casual employment relationship. In context, that would suggest that offer of work is service. So offer of work, service, offer of employment would seem to be the creation of a contract of employment as a result. The employment may well be there referring to contract of employment, maybe referring to the employment relationship, but it's a broader thing than merely the offer of work as such. The other thing is that in the considerations that are taken into account, there is really no right to expect to be provided with work during the relationship. The factors that are in C and D are easily dealt with. They can just be included in the document, describe the person as a casual employee, etc. And whether the person works only as required. So we have this ongoing relationship that's created by the offer of employment. We have the question of what work is done during the relationship, and we're told that it will be casual employment until we get to an alternative offer of employment. A few observations in relation to that. Is the meaning of each of the factors which are identified as being the only factors to be taken into account in subsection 2 influenced in any way by the other factors in subsection 2? Or is it influenced by the language in 15A1? One can think of some examples whereby there is an offer of employment, which might be, we might require you to work from time to time, and then there being an offer of work, and the offer of work being for a period of 12 months, something like that. Technically, that might still fit within the definitions, but one would think is not in accordance with the purpose of the Act. The other is, what of the variation of existing contracts of employment, where you've got a Quinn and Jack Chia type situation, where there's some change in the employment relationship. So what might be seen to be a later offer of work under subsection 2 is actually an alternative offer of employment, because it's at a different place, might be on different rates, might be a different sort of work. And so there'll be issues there, I think, which are going to be quite problematic. The last two bullet points are worthy of consideration too, but I won't dwell on those at the moment given time. I do want to talk a little bit about casual loading. It's always occupied this role of being a safety net function. The rationale for casual loading has always attached to the entitlements that an employee forgoes, such as annual leave, sick leave and the like, notice of termination, severance pay. The other thing that's apparent from the authorities is that it's hard to be precise about the individual components of the casual loading. In the Metals Casuals case, the Fair Work Commission had a go at identifying components of the 25%. And over a series of some 40 or so paragraphs, they came up with the assessment that really 20% could be attributable to paid leave entitlements alone. At that point in time, the casual loading was traditionally set at 20%. 20% was the norm. And following this analysis, the full bench said, well, look, 20% probably really only accounts for leave components. We've got other components too. What about the lack of security in employment, the absence of the entitlement to notice or severance pay, issues of itinerance, lost opportunity to work consistently and the like. And the full bench came to the view that that was worthy of about 5%. And in those circumstances, set the loading at 25%. I just want to put that in the context of history. When one looks at the award test case standards, working hours varying over time, annual leave changing over time, carers leave changing over time, notice and severance pay largely from the TCR case in 1984 onwards, the components which the casual loading is intended to compensate employees for the absence of those entitlements have, of course, changed over time. And thus we end up at the point in 2000 where the full bench makes the assessment that it's worth 20%. We come then to the era, of course, of statutory minimum entitlements rather than award-based entitlements. Through the award rationalisation process in work choices, first of all, the award simplification process through the 93-96 reforms, confining awards to 20 allowable matters, including loading, then through the award rationalisation process, which of course never really got underway, the preservation of an entitlement to loading under the Australian Fair Pay and Conditions standard, anchored back at 20% rather than 25%. And then, of course, the move to the broader-based statutory minimum entitlements under the Fair Work Act and the dealing with and the assessment of what is an appropriate casual loading under that regime. So we turn to that question, and what the Fair Work Act does in relation to casual loading is says it's really a matter for the awards, but the annual wage review panel will need to set the minimum casual loading for modern awards, and in the absence of any application of a modern award, needs to set a default casual loading. So in the initial annual wage, the award modernisation process, the Fair Work Commission stuck with the 25% that was landed on by the metals casual case some 8 or 10 years earlier. But because the Fair Pay and Conditions standard under the predecessor legislation was at 20%, it needed to manage the move from 20 to 25%. And that would be adopting a base rate of 25% based on the generally sound reasoning in the metals casuals case, but then using the annual wage review process to escalate that minimum from 20% to 25% over the years from 2010 to 2014. We then have the situation where by 2014, the rate is 25%. So coming to this question of what's the loading paid for, and what about this issue of compensation when someone has a claim for NES entitlements in circumstances where the employee and the employer thought the employee was a casual. The starting point is an observation that's been made in a number of cases now. That is, us industrial lawyers, we're a bit loose with our language. We use set off. Really all we're talking about is an argument that the entitlement's been paid in part. It's not really set off in the traditional sense of setting off a debt against another. And in the casual loading scenario, the claim is really that the employer should be entitled to have some portion of the casual loading that it's paid over time brought into account to discharge the entitlement that's being sought. And that then butts up against this requirement that has been in place for some time under the old provisions in sections 178 and 179 of the old Industrial Relations Act, that there be this close correlation between the payment that is relied upon and the entitlements actually claimed. And there's the line of authorities. The original authority was Ray and Rodano, and then Pacific Publications, then those authorities. But I just draw to your attention that those authorities have all decided under the old 178 and 179, which really provided for recovery of underpayments as a liquidated sum or as a debt. And there were some limitations on the ability of the court to deal with those sorts of underpayments. There was no broad discretion to give more or less than the amount. If there was an underpayment, the court had to order recovery of the full amount. In the full court decision in Rosato. This was the issue that provided an impediment to WorkPac relying upon the underpayment, relying upon the payment of casual loading to satisfy the payment that was claimed. And the full court relied upon a decision of the full court of the Supreme Court of South Australia in Trans Adelaide and Leddy to say, well, look, really, what we're talking about is a payment of money for foregoing an entitlement to paid leave. We're not talking about payment for leave. So they picked up that distinction and they said that that really lacks the close correlation. And the full court distinguished between also an entitlement to money on the one hand and an entitlement to leave on the other. And so the full court said there's not this close correlation, and so it was not open to WorkPac to deploy the payment of the casual loading over time to satisfy any entitlement to paid annual leave under the NES. What about the position under Section 545? There's a broad discretion to make any order the court considers appropriate to compensate for loss that a person has suffered as a result of the contravention here, the absence of the conferral of annual leave. Arguably, that's not the same as the right to sue for and obtain an order for payment of compensation, for payment of an underpayment, making good an underpayment by recovery of a debt. That distinction was identified briefly by Justice Murphy, really in some passing comments in one of the class actions in Gall and Dominoes. But I raise it because it may well be, absent the amendments that have just been made, there is an argument that it would be open to a court to exercise the discretion to avoid an employee securing a double entitlement. In Rosato, the point really as to compensation doesn't come up because, as I mentioned earlier, we've got an employer seeking declaratory orders. But on reviewing the written submissions and the oral submissions in the High Court, it's apparent that WorkPac and the Minister intervening are seeking to agitate this issue that I've just mentioned. In the meantime, of course, we've got the Amending Act. Now, again, the Amending Act is a little problematic and it creates more issues than it answers. It applies in the limited circumstances in 545A1. It's only a provision which applies at the remedy stage. What orders can the court make? It's not something that applies so as to prevent there being a contravention. The next point I make is that it gives the court a broad discretion to reduce the amount of compensation to account for what has been paid by way of casual loading. It's limited only to the circumstances where there is this mistaken belief as to the nature of the relationship. And we've got the traditional entitlements which are bought out by the casual loading, in respect of which the court has this limited power. I raised the question there at the foot of that slide as to whether or not in determining the appropriate proportion, one reverts to the generally sound reasoning in the assessment of the 25% in the casual loading. Then in the new provisions, and I'll finish on this because I'm conscious of the time and want to leave some time for questions. We've got these bizarre additional provisions that are in Schedule 7 to the Amending Act. Schedule 7 to the Amending Act amends Schedule 1 to the Amending Act. And tries to give it both retrospective and prospective operation. Again, we have one of these avoidance of doubt provisions, which is in 46.4. For the avoidance of doubt, an employee who could have claimed relevant entitlements, but for their designation as casual employees, has not accrued and cannot make a claim for those entitlements. I'm not sure how that can be something that arises by reason of there being any doubt in section 545 capital A as drafted, a provision which, as I mentioned, deals with the making of any orders. There is also a foreshadowed challenge to the constitutional validity of section 545A. That leaves us in this position. Can you get any more certain than this? Tension between what one might say is 100 years of industrial history and decisions of 2 recent full courts of the Federal Court. In identifying whether someone is casual, we've still got to resolve this issue of the application of the general law statutory minimum entitlements, general law to those statutory minimum entitlements, and of course, the engaged and paid as such definition. We've got the problems with the statutory revisions that I've really only touched on through the course of the discussion, and the High Court about to make a decision on existing provisions. All of that, really without even turning to issues such as conversion and the transitional provisions there, and I haven't even touched on the availability of cross-claims seeking equitable relief, such as monies paid by mistake or failure of consideration, which are subject to consideration in Rosato. So the ultimate conclusion I reach is that we, at the moment as we stand, are in no more certain a position than we were before the recent amendments. John, I'm sorry to have taken so long, but hopefully that has been of value, and I'm happy to field any questions.
Thanks, Paul. I'm sure everyone will agree that was, extremely forensic dissection of the cases and the new statutory provisions, but a somewhat, I guess, worrying conclusion that we're not any closer to certainty. We've had a few questions in the chat. We don't have a huge amount of time left, but I'll take a few of them as rhetorical questions. But the first question I've got here, Paul, from Kelsey Hunter, is about casual labour hire employees. Can they ever qualify for casual conversion, given their employment is by its nature unpredictable as it relies on their clients' needs?
That's a valid point. I suppose the question is whether at any point their employment may well be said to be regular enough. And that's something we'll just have to wait and see. It's a difficult call to make. I think one thing with all of these relationships is that they'll turn on the particular circumstances of the case. Many of the cases that are before the courts by way of class actions arise in the open coal mining sector, where there are labour hire companies that are engaged by the mine operators. I'm not sure that the fact that they're engaged by a labour hire agency would be an impediment to casual conversion being available to them. That's just one example. There will be others where the nature of the labour hire may prevent them from ever getting access to the casual conversion provisions. As I said, it probably turns on the circumstances, John.
Thanks, Paul. I've got another question about awards dropping a reference to notice of termination and severance pay from the things that the 25% loading covers. What do you think is the significance of this?
It may well have significance in terms of the operation of new section 545A. If I go back to the slide in relation to that, provision, you'll see that there's this ability to apportion what is paid by way of leave loading to certain amounts, and a court has to reduce the amount payable by the employer for the relevant entitlement. This is in circumstances where the award or agreement might identify the apportionment of the leave loading. In circumstances where there's an identification of the matters that are to be compensated for by the loading, but no apportionment, the court can make its own appropriation, if you like. And 545A4 deals with the circumstances of an absence of any apportionment at all, and the absence of any identification of what the leave loading is for. So in circumstances where you've got an award which drops the entitlements to notice and severance pay as being something that's compensated for by payment of the leave loading, it's likely to leave the employer in a position where they can argue that a larger part of the 25%, if not all of the 25%, should be taken into account in setting off the leave loading against the claimed entitlement to the NES annual leave entitlement and the like.
Thanks, Paul. Another question is from Marilyn Pittard. There's been a lot of discussion of long-term casual lecturers at universities. Do you see the casual conversion provisions being used extensively in this sector?
They could very well. They could very well. Any sector where there's a high level of use of casual employees, one can see there being the potential. And again, in the tertiary sector, there's a whole range of arrangements. One might be that someone teaches a particular course which only arises in one semester each year, and might be for 6 or 8 or 12 weeks in a particular semester and is only certain hours. Now, one might say, well, that is regular and systematic employment, even though it's only over part of the year, and it might have been going for some years. And in those circumstances, it may well be that the arrangement can fit within the casual conversion provisions. Again, turns on the circumstances, but quite possible, Marilyn, that's for sure.
And one final question, Elizabeth Shee asks about, in the context of the recent FWC decision in Franco and Deliveroo, are we likely to see this kind of statutory, this use of a statutory definition coming in other areas like the gig economy workers and their employment status or otherwise?
In terms of a definition of employee being filtered into that sort of statutory scheme, maybe, or the use of casual employment, definition of casual employee having some use. There may be. I mean, those sorts of cases, the distinction between someone who's not an employee, I use that phrase rather than independent contractor. Distinction between someone who is not an employee and someone who is a casual employee is more problematic than the distinction between someone who is not an employee and someone who is a full-time or part-time employee, if you like. So I suppose, Elizabeth, all I can say is that there may well be some work to do on the definition of casual employee, which brings the gig workers closer to being employees. It's almost like a stepping stone along the way. There is a potential for that argument to be raised. Again, we'll just have to wait and see.
Thanks, Paul. We're out of time, but and I see a number of people having to leave us, but there's lots of thank you messages appearing in the chat, complimenting you on what a fantastic session it's been. And I concur. Thank you very much, Paul, for your comprehensive analysis of these provisions, and we'll have to see how they play out over the next few months and years. And thank you for being willing to answer questions as well. We really appreciate your time and your willingness to present the seminar on Zoom. I just also want to thank Tess Hardy, co-director of the Centre, for helping to organise this, and also to Diane Holland, who facilitated the technology tonight. And thank you everyone who came online to watch and listen. And I hope to see you all at the next Centre for Employment and Labour Relations Law seminar, which we hope will be face-to-face.
John, can I just mention that the slides will be uploaded? I'll hand those over to Tess and people can access those as they see fit.
Thanks, Paul. And the recording of the webinar will also be posted on the Centre website.
Okay, thank you, John. Thanks for your hospitality.
Thanks, Paul. Thanks, everyone.